morning.
Good morning.
Before you begin, you can assume that we have all read very widely and that we also think that the time estimate is very generous.
My lady, I'm very grateful for that indication. I appear on behalf of the Panayi appellants. Mr. Margolin, King's Counsel, appears for the Redevco appellants. Mr. Mark Bell, King's Counsel, and Mr. Elliott appear for HMRC. By way of housekeeping, you should have a timetable from the parties. I hear your ladyship's indication. We will obviously do our best to move through the appeal as swiftly as we can. On the current timetable, the taxpayers will stop at around 12:30 tomorrow. For my part, I'll have until perhaps 3 o'clock this afternoon, and then Mr. Margolin will address you in the remainder of that time. Finally, in terms of housekeeping matters, you should have 4 authorities bundles, a core bundle, a supplementary bundle, and also a supplementary authorities bundle, which will probably be rather slim and that arrived yesterday and reflected the fact that some of the statutory material wasn't in quite the right form. Did that make its way to the court? I'm very grateful. That's exactly what I'm referring to. And the last...
Sorry, I seem to have 10 authorities.
Yes.
You may well do. Well, it may be that my clerks have been very stingy in their bundling and have packed them tightly, double-sided.
But put it this way, we have the last tab is 101.
I'm very grateful. I have 102. Let me just check what 102 is.
No, I have 101, and then I've got this supplementary.
Well, my lady, if there's, I have 102, which is slightly confusing. Let me see how we go.
Let's see.
If we find that I'm one authority's tab out, then I will adapt on my feet as I go. The last point to pick up is the transcription. We have a transcriber today. For that reason, with your permission, we'll take a short break in the middle of the morning. I've been asked to...
Short breaks become long breaks.
Well,
I do appreciate how difficult it is. But I think that we have a lot to get through and that we should not have a break. Thank you.
I'm very grateful, my lady.
Just on the last point, I've checked volume 10, and although the label says tabs 88 or 101, it actually contains a tab 102.
Oh, thank you very much.
I'm very grateful. That resolves some anxiety on my part. So, my ladies, my lord, with your permission, I propose to use my time as follows. First, an introduction and a summary of my submission. Second, the background facts, the procedural background to the appeal, and in that context, I'm going to be covering the domestic statutory regime, which is obviously critical. Third, the relevant case law, and under that heading, 2 areas. First, exit charges in EU law, and then conforming interpretation in UK law. Fourth, the judgment below. Fifth, my grounds of appeal.
And as I say, you won't need to spend too much time on background because we have read widely.
I'm very grateful, and I will try to rattle through it as quickly as I can. Just to round out this introduction and to try to summarise my submissions for you in a nutshell, this appeal raises, in my respectful submission, a fairly straightforward question of law. Does the court's power to find a conforming interpretation of domestic law extend to the reading into UK legislation of a novel and detailed statutory scheme for the payment of tax? So that, in my submission, is the question at the heart of the appeal. And my submission, my core submission, is that the jurisdiction to find a conforming interpretation is, of course, a muscular one, but it is not that muscular. And therefore...
But this involves bodybuilding.
Well, my lady...
You would say.
Indeed, indeed. And therefore, the finding of the Upper Tribunal went well beyond statutory interpretation and strayed into into judicial legislation. And that's because the Upper Tribunal found that it could read into the Taxes Management Act 1970 a scheme whereby taxpayers liable to pay capital gains tax at the point of leaving the jurisdiction, where they are moving to an EU member state, are entitled to choose to pay that liability in 5 equal staged payments on an annual basis. And in my submission, the retrospective reading in of that statutory scheme goes well beyond statutory interpretation, even conforming interpretation, for 3 reasons. First, it crosses the Rubicon of making a novel statutory scheme. And there's clear authority that I'll be coming to this morning that the making of such schemes is an act of judicial legislation. And the proof of that submission, at least for these purposes in my introduction, is that Parliament has made precisely such a scheme in direct response to the ruling of the Court of Justice in this case, or at least in my case. And it consisted of a 7-page schedule to the Taxes Management Act, and I'll take you to that shortly. And in my submission, that is a rather striking state of affairs and rather goes to the nub of that first reason. Second, because it involved the tribunal choosing between different policy options, and only Parliament is equipped and indeed entitled to make such choices. And the solution in the judgment that the Upper Tribunal used to circumvent that problem, which was to say this is the best fit with EU law and we're going no further than EU law requires, is in my submission no answer to the unavoidable reality of this case, which is that the Upper Tribunal made complex policy choices between different kinds of scheme. So those are the first 2 points. They made a scheme, and in doing so, they made impermissible choices. Third, the conforming interpretation in this case falls foul of the principle of legal certainty because it involves the offer to my clients of a choice that they were never able to avail themselves of. It is a wholly hypothetical choice. So perhaps rather boldly, at the heart of this appeal is a plea for judicial self-restraint.
Can I just sort of interrupt and ask
Indeed.
a question, please, Mr. Johnson? Is it realistic to think that your clients, if offered the choice between paying the whole amount up front and paying in instalments, wouldn't have gone for instalments?
Well, my lady, that question itself, in my respectful submission, identifies precisely the hypothetical nature of the exercise here. What is being done is, firstly, my clients are being told that they had a hypothetical choice. Secondly, it is being hypothesized what they would or would not have done at the relevant time. I can take instructions from my client if you want over the adjournment as to what they would or would not have done, but in a way that the answer.
I don't need you
to do that.
Thank you.
I'm grateful. But the very fact that in 2026 the question might be asked, what in 2004 would you have done had there been before you a hypothetical choice never adverted to by the revenue until 2018 at the first time? That, in my respectful submission, unpicks, if I can put it that way, the artificiality of the exercise in this case. So as I say, at the heart of the plea, the heart of the appeal is a plea for judicial self-restraint and also for fidelity to the words that Parliament chose when making UK tax legislation.
Can I just ask another question?
Of course.
Did your clients pay the tax at the time? I think they didn't. Is that right?
No, absolutely. What they did is they...
So they haven't ever paid the tax?
No, indeed. And because of the extraordinary protracted nature of this case, in fact, we're in a strange position now where the interest exceeds the capital sum. They didn't because they filed a tax return in which they did not notify that they were liable for capital gains tax for the reasons that they're still arguing in 2026. The Revenue opened an investigation into the tax return for 0405. There was then an appeal. That was then appealed to the first tier tribunal and then the reference and so on. And I'll talk briefly through that background and say what we take from it in a moment. So that's ground one. Ground two relates to whether the proposed conforming interpretation remedies the breach of EU law in this case. And my submission does not. And that's because the breach is the failure to offer a choice at the exit date. So this ties back to, it's connected to, the submission I was making earlier under ground 1 in relation to legal certainty and the fact the appellants were offered no choice in this case. And Mr. Margolin is going to address you in more detail, just so you know where we're going and how we're dividing between us, specifically in relation to the questions on legal certainty. He's going to elaborate on the relatively brief submissions I'm going to make. Ground 3, if and only if, and this is very, very much a submission in the alternative, if and only if conforming interpretation is open to the court in this case, in the sense that it doesn't involve judicial legislation. The better approach, in my respectful submission, is to make an amendment such that liability is deferred until the asset is realised. That's considerably less complex, it's considerably less elaborate, and in fact it's what HMRC itself was suggesting when the issue of conforming interpretation was first raised. So those are my submissions in a nutshell. I propose now to move on to my second heading, which is the factual, statutory and procedural background. And I hear what my ladyship has said about your familiarity with that. I hope I can cover it then in 4 points. First, this appeal is brought by the trustees of 4 trusts, settled by Mr. Panico Panayi in 1992 on his children and other family members. And in 2004, Mr. Panayi decided that he would return to the land of his birth to Cyprus. And so he appointed new trustees there. And as I've already said, on departure, the trustees did not declare any CGT to the revenue in the 0405 tax return. That's the first point. The second is to look at the statutory regime as it existed in the tax year 2004 to 5, and that in some ways it is at the heart of this appeal. So for that, if I could ask you to turn to authorities tab 14, I'm not going to be able to assist you very much in terms of bundles, because it appears that my bundles are, as we mentioned earlier, considerably less generous than yours, but I anticipate it'll be in bundle 1.
It is in bundle 1. I'm sorry, you said 14 then?
14, starting at page 144. So this is section 69 of the Taxation of Chargeable Gains Act 1992 as it stood in 2004 to 5. And we only really need to take from this particular section, subsection 1, in relation to settled property, the trustees of a settlement shall, for the purposes of this Act, be treated as being a single and continuous body of persons, and that body shall be treated as being resident and ordinarily resident in the United Kingdom, and here's the key part of it, unless the general administration of the trusts is ordinarily carried on outside the United Kingdom, and the trustees, or a majority of them for the time being, are not resident, or not ordinarily resident in the United Kingdom. So that is the change that occurred in 2004. Mr. Panayi moved home to Cyprus and appointed trustees there. So that provision was engaged at that point. And that then leads us over the page to page 146 and section 80. And subsections 1 and 2 in particular are key here. They are a deeming provision. This section applies if the trustees of a settlement become at any time neither resident nor ordinarily resident in the United Kingdom. So that's referring back to the language of section 69. The trustees shall be deemed, for all purposes of this Act, A, to have disposed of the defined assets immediately before the relevant time, B, to have immediately reacquired them. And what follows from that deemed disposal and acquisition is the obligation to pay capital gains tax. Now for that, if I can take you, it will be obviously in the first bundle to tab 2. I was slightly thrown by tab 2 because it has page 19, A, B, C, D and E. So when you're navigating within it, you'll note that there's numbers followed by letters. At page 19.0, which might initially look like page 190, but it's 19.0, is the relevant provision for these purposes. And here we have section 59B, which governed the mechanism for the payment of that capital gains tax. So subsection 1, subject to subsection 2 below, the difference between the amount of income tax and CGT contained in a person's self-assessment under section 9 of this Act for any year of assessment, and the aggregate of any payments made on account, and any income tax which in respect of that year has been deducted at source, shall be payable by him, or as the case may be, repayable to him, as mentioned in subsection 3 or fall below. So what that's capturing is simply that by netting off payments and so on and so forth, that's how the liability arises. And then subsection 4 over the page on 19p is the provision that was engaged here. In any other case, the difference shall be payable or repayable on or before 31st of January next following the year of assessment. So in this case, the CGT in dispute is said to have arisen in the year 0405 and so was payable by 31st January 06. So that is how the law stood in 2004. If you leave the jurisdiction, you have to pay CGT on the assets, and that obligation falls to be paid in the January immediately after departure. I'm going to return in a moment to how the law is now, but that's just to capture what it was in 0405. So that's the second part of the factual background. The third factual piece to be aware of is that the relevant shares were actually disposed of by the trustees on the 19th of December 2005. Now that's not contentious or in dispute, I don't need to turn it up. If you want a reference for your note, it's at Mr. Panayi's witness statement at supplemental bundle, tab 19, page 219, at paragraph 65. So that's the disposal of the shares. And this is relevant, I'll come back to it for the purposes of ground 3, because you'll note that the disposal is not in the year 0405, it's in the year 0506 in tax purposes. Fourth part of the factual background. Following that departure, there has followed what is on any view a very long procedure. So to rattle through it as quickly as I can, in 2010, HMRC closed its inquiry into the tax return for the year 0405 and found that CGT was owing. And it's important to note that the appellant's position as to why CGT was not owing has always been the same argument. So, and we'll find that in Core Bundle tab 26, starting at page 489. So this is a letter from Montpellier, my clients then accountants. First paragraph introduces them. We act for trustees. We are instructed to appeal against the closure notices. So I make sure I give you enough time to find the references. So it's Core tab 26, 489.
Yes.
In each case, the grounds of appeal are the same. First, the amendments are wrong in law since they impose a charge to tax under section 80 TCGA, which we've just seen, on the appointment of trustees resident in Cyprus and the transfer of the residence of the trustees of the settlement to Cyprus. This exit charge is contrary to European Community law, now European Union law, in that it infringes the fundamental freedoms, including one or more of the freedoms of establishment, free movement of capital, freedom to provide services, and free movement of persons. So that is my client's position, and that has been their position throughout over the intervening period. And in fact, I won't take you to it, but it's their position going back. That's what they're discussing when they're in relation to the original inquiry into the tax return. The revenues case, on the other hand, has evolved very considerably. And I think it's not unfair to say that the issue before you is HMRC's final throw of the dice in its evolving attempt to argue that CGT was payable on departure. And the first position you'll find at tab 27 of the core bundle on page 492. So this is the revenues letter of October 2012 in relation to the appeal. There's a typo in the first page, just, you appealed against my decision of 29 September 2010, it should say, not 2012, amending your self-assessment return. So this is somewhere down the line in response to the letter we've just seen. Turning over the page, we get the reasons why the appeal is being refused. Second bullet point, at trust, I think that should say as a trust. The settlement is not a national of a member state, nor is it a legal person like a company, so that it does not enjoy the freedom of establishment accorded under EU law. So because you are a trust, you are wrong to say you take the benefit of EU law. However, even if EU law, so this is the second argument, even if EU law did apply, the courts recognise it is reasonable that the original member state seeks recovery of a tax debt following realisation of the assets transferred abroad. So, a charge under Section 80 TCJ 1992 would be reasonable in this case once the trust sold the assets, i.e. after December 2005. Also, as reasonable, the recovery of late payment interest on a tax debt as though it were a loan to the company. So what's being said is, A, you're a trust, you don't take the benefit of free movement. B, in any event, it's proportionate in this case because you actually sold the assets in December and payment wasn't due until January. And so therefore it's proportionate. So that's the revenue's response. And we'll see that as well in the revenue's original pleaded case before the first tier tribunal, which is at Core Tab 30, page 510. I won't take much time with this, but just to deal with it very briefly. Paragraph 36, page 510, the Commissioner's case is A, it is for the appellant to establish that the relevant fundamental freedoms are engaged. B, in any event, Section 80 is not inconsistent with the appellant's rights under any of the fundamental freedoms. And if you read through that, and in particular 43, they're making the same argument, which is the Commissioners were entitled to receive it because this was after underlying. The appellants had disposed of the relevant shares. And if you turn over, that's their pleaded case in April 13. So those questions, in effect, A and B, were referred to the Court of Justice by the First Tier Tribunal in December 2015, and you have the order for reference at Core Bundle tab 21. I don't propose to turn it up. It was broken down actually into a slightly different cluster of questions, but those 2 points are the kind of nub of the reference. What I would like to turn up is the Court of Justice's findings on this issue. Starting very briefly first at tab 22 with Advocate General Cocotte's opinion. She deals with the first issue at paragraph 46. You'll find that on page 386 behind tab 22 of the core bundle. The answer to the first and third questions must therefore be that the freedom of establishment is restricted where a trust or as such or in the person of the trustees is taxed in the event that its place of effective management is transferred to another member state, but not in the event that its place of effective management is transferred within a national territory. So this is answering the trust question, and they're saying, yes, trusts are entitled to take the benefit of the fundamental freedoms in EU law, and the distinction being posited is between a trust that moves outside of the member state and a trust that remains in the member state but moves from London to Birmingham or whatever it might be. The freedom of establishment is restricted in those circumstances. Just to pick up paragraph 51 over the page at 387, I'm sure my learned friend will want me to refer to it. The answer to the first part of question 2 and question 4 must therefore be that an exit tax such as that in issue here is in principle permissible for the purposes of preserving the allocation of the powers of taxation. So this is an important point. The point that's being made here is there are lawful ways in principle in which capital gains tax may be charged at the point of departure. There is no dispute between the parties as to that. The simple submission just to foreground it at this point is there are many, many lawful ways in which tax may be charged. That is not an answer to this appeal. The question raised by this appeal is whether or not a scheme may be read in to do so after the event by conforming interpretation. And then if we turn over to paragraph 58, page 389, the tax at issue in the present case, therefore, remains disproportionate, despite the fact that the hidden reserves were realised before the due date of its payment, because there was no option, and we do underline the word option, to defer payment at the time of the assessment of tax. Such an option to defer, and again this is also important, does not necessarily have to amount to the 5 years referred to in the court's case law. And you'll apprehend immediately why I rely on that sentence, because it's going to go to my submission about the making of choices. The UK legislature could instead have linked the option to defer to realisation of the hidden reserves within the 5-year period. So that's the core answer from the AG. Very quickly, tab 23, the Court of Justice. starting at page 402. The same bundle, so it's just the next tab along. Paragraph 43. This is important because it's something that the Upper Tribunal did not appreciate and misdirected itself on. All measures which prohibit, impede, or render less attractive the exercise of the freedom must be considered to be restrictions on the freedom of establishment. And that's the critical starting point for this case, which is that any measure that makes it less attractive to move to another member state is a restriction on the freedom of establishment. It's not that it's only a restriction on the freedom of establishment if it's disproportionate. It's always a restriction. The question analytically is how or in what way might that be rendered lawful. Then turning through from there, paragraph 57. I might leave you to read that rather than read it to you because it's on the longer side. So again, I know a friend would take you to this. Again, the point I take from it is that there are multiple different ways in which this might be done. And then final, paragraph 59, it's apparent from the document submitted to the court that the legislation issued in the main proceedings provides only for the immediate payment of the tax concerned. It follows that such legislation goes beyond what is necessary to achieve the objective of preserving the allocation of powers of taxation between the member states and constitutes therefore an unjustified restriction on the freedom of establishment. So that's how things stood on return to the FPT. HMRC had lost on whether trusts were capable of benefiting from the fundamental freedoms, lost on its point about disposal. And the next iteration of HMRC's pleading, or next argument rather, is at supplemental tab 21 at page 234. That may be a bad reference because supplemental tab 21 is not page 234, that's the reference. My apologies. Let me see if I can find it. If I can't, then I'll go to the page itself and see if I've just... My apologies, if I could have a moment just to... Yes, of course, sorry. I have somehow misdirected myself there. But let's just go back to the core bundle then, tab 31. This is the pleading that we get on return. So it's the Commissioner's amended statement of case. And it's important to note that at no point before the end of 2017, after we've returned from Luxembourg, 13 years after my client left jurisdiction, had the Revenue ever suggested that conforming interpretation was the means by which the unlawfulness of the UK tax law might be rescued. And that is set out in the pleading here, the amended pleading for the first time. And we'll find it, so it's tab 31, core bundle, starting at page 522. It'll be: it is well within the scope of conforming interpretation to read words into sections 59B, 1 and 4, Taxes Management Act, to make clear that the obligation to pay the difference between the amount of capital gains tax contained in a person's self-assessment for a tax year and the aggregate of any payments on account made by him in respect of that year by the 31st of January next, following the year of assessment, so that's the provision that we've seen, is deferred to the extent required by EU law. And then we underline what's in brackets, i.e., in the present case, until the date of realisation of the shares in Cambos, namely 19th December 2005. So the conforming interpretation being argued for, and if you turn over the page to the latter half of subparagraph C, you find this again. Actually, maybe take it from back over the page. This requires the date in which the obligation to pay the difference between, turning over to 523, the amount in capital gains tax contained in a person's self-assessment for a tax year and the aggregate of any payments on account made by him in respect of that year to be postponed until the date of realisation of the shares in Campos, 19th December 2005. So that is the conforming interpretation being advanced by HMRC when we get back before the first tier tribunal. It's not their case now, and I'll explain in a moment why that is. But two things, maybe three things to note that are relevant to my later submissions. The first is a point I've already made, which is we are now 13 years on, 14 years on from my clients leaving the jurisdiction. It's the first time that this argument in relation to conforming interpretation is being canvassed. Had my clients argued in 2004 that they are entitled to pay by any kind of deferral, whether it's until realisation or in instalments, HMRC would have said absolutely no way. And we say that is squarely relevant to the question whether my clients were ever given a choice, because choice is the hallmark of the EU case laws.
Does it matter what the revenue says, or does it matter what the law is?
Well, it matters what the revenue says as regards my ground 2. Because as regards my ground 2, the kernel of ground 2 is to say that it is necessary to give the relevant departing party the choice. The word choice, choose, option runs right through as the thread through the EU case law. And in circumstances where that choice was not available, the submission is under ground 2. You can't read it back in because it's not a real choice. It's a hypothetical
If it was available in law, does it matter what the revenue says? The revenue often says to people, you've got to pay me lots of tax. And the taxpayer says, no, I don't, because the statute doesn't mean that.
Yes.
And the revenue can huff and puff and say, pay me the tax.
Yes.
And the taxpayer can go to court or tribunal
And win
and
or
say,
lose.
no, I don't.
Yes.
Very often the tribunal decides that no tax is payable, which is why it's a serious question.
No, absolutely.
Does it matter what the revenue would have said in those? Is that the real question? What would the revenue have said? Or is the real question, what was the law?
So two parts, I think, to the answer to that. The first is that this touches on the question of retrospectivity. And it goes to a part of the revenue's case, which is to say, look, all conforming interpretation is retrospective, and therefore we don't understand all of your complaints about legal certainty and retrospectivity and so on and so forth. I don't want to tread too much on Mr. Margolin's territory, but let me summarise my submission briefly. There are different kinds of retrospectivity. And the example you've posited for me is one in which the question is tax owing or is tax not owing? This is an unusual case because the necessary thread in the authorities is the choice. And so it is time bound. And that's why I'm going to be making a submission to you later that this is much more akin to Fleming, which, as you may recall, is a case about whether or not you can read in a transition period that people can't actually in the real world take advantage of. And the Supreme Court says, no, you can't do that by way of conforming interpretation because it's wholly hypothetical. So this isn't an attack on retrospectivity in principle in tax cases at all. My submission is that this is an unusual case. And what's unusual about this case is that it was necessary to be lawful to have the choice at the time. It is a time-bound lawfulness, if I can put it that way. It's not just is tax owing or not. And that's why this case is unusual. And that's why the question of conforming interpretation and retrospectivity, some of the authorities relied on by my learned friend don't bite, we say. And we say this really is a Fleming case. You can't say in Fleming, well, there's a hypothetical opportunity to take the benefit of a transition period that wasn't there at the time and you couldn't do so. And the Supreme Court's very, actually maybe the House of Lords is very clear on that, that you can't. And we say that we're absolutely in that territory. So that's the first part. The second part of the answer to the question is, you're absolutely right, my lord, to say that both sides in this case can, have a submission about this in a moment, but both sides in this case can effectively make submissions about the unattractiveness or otherwise of the other side's case. And my learned friend's case is, look, this is enormously unattractive. You're trying to turn a right to pay in instalments into a right not to pay at all. And I can say, well, this is something that's been magicked up out of a box of tricks as the very last argument that you might ever have. That gives you problems on retrospectivity, but it's also enormously unattractive. But you're right to say, my lord, that actually the critical question, irrespective of who, inverted commas, is the opportunist in this case, and my client's view for the avoidance of doubt is that that is not them. The question is, what does the statute say and what does the law allow? So even if you were to be against me on my ground 2 point in relation to retrospectivity, the kernel of ground 1 is to say this is not allowed by way of conforming interpretation. We have to be faithful to the Act as it was. Of course, conforming interpretation is very muscular, but as I said earlier, not this muscular. And so if I'm right on that, then HMRC's complaints that this is some kind of opportunism on my client's part, and my complaints that HMRC is being opportunistic by way of its changes of position, don't resolve that critical point. And with respect, I think the Upper Tribunal, I was going to say slightly lost its way. I think that's unfair. I think the Upper Tribunal was unduly influenced by the question, well, why should my clients be entitled to pay no tax? To which the answer is, that's not the right question on this appeal. The right question on this appeal is, what does the law say? What does the statute say? And can this court read in a scheme to amend it in order to impose a liability to tax in circumstances where the starting point is that the statutory regime is not lawful? And so I absolutely take your question, my lord, and I suppose I'm possibly having my cake and eating it by saying, yes, it does matter, but also in relation to my primary ground 1 case, I don't need that point. I hope that helps.
But in fact, you're saying, first of all, it can't be done.
Yes.
And secondly, you're saying, if it could be done, then you're in a Fleming-style situation because you could have never had that choice because time had already elapsed.
Absolutely.
And that's got nothing really to do with the position that the revenue had taken or not taken over time. It's to do with whether it is possible to have a conforming interpretation and what that interpretation is.
Indeed. I suppose the only other reason that I refer you to what HMRC said in 2018 is for 2 reasons. Firstly, because their primary case is now my ground 3. And the reason that their primary case is now my ground 3, or their primary case in 2018 is now my ground 3, is because the thrust of ground 3, to capture it briefly, is that if conforming interpretation is appropriate in this case, we say no, but if it is, the proper conforming interpretation is that the liability should be deferred until realisation of the assets. And that's what HMRC was arguing at that point. Now, the reason that's been abandoned is because if that's the case, then there is no liability to tax in this case. And the reason for that is because the inquiry was opened into the tax year 2004 to 5. This is a disposal in the year 2005 to 6. And therefore, if the proper conforming interpretation is that there should be deferral until disposal, then HMRC opened its inquiry into the wrong year. It's much too late to open an inquiry into 0506 now. So we do say this goes to 2 points. Firstly, we say, if you're with me, we think HMRC's intuition was right. Sorry, if you're against me, rather, on grounds 1 and 2, we think HMRC's intuition is right, and that's on my ground 3. It also goes back into ground 1, though, because it goes back to the question of choice. And we say what you see here is, even within the revenue's own case, the evolution is a point that goes to my submission about making policy choices. There are just different ways in which this can be done, multiple different ways in which this can be done. The revenue itself has argued for different ways in which it might be done at different times. And that, we say, is the proof of the submission, my primary submission, under ground 1.
I'm sorry, I'm just reading their pleading. Are they actually saying that, one view of their pleading is that they're saying the obligation to pay only arises on the disposal taking place, but it's in respect of the tax year when you leave.
But if the obligation to pay arises in one tax year, then going back to the provisions that we've seen earlier, if the obligation to pay arises in 0506, then the payment date is the January of the year after. So it would have been January 07 in those circumstances. So if the obligation to pay crystallises in December of 05, you're within the tax year 5/6 at that point. So then the obligation to pay under the ordinary rules about when it crystallises and when it becomes owing is that it becomes owing in January of 07.
You could easily have a system where you said that there's an obligation to pay in respect of the tax year when you leave. But so there's an obligation to pay, but you can defer payment until you've actually
realised the asset. And that then goes to, and it may be
but
that.
Is that
Well, in those circumstances,
this may be quite a semantic debate.
It may be a semantic.
Exactly what this is, but it seems again rather a kind of get out of jail free card, if I can put it that way, to say that because the realisation actually took place in the following tax year, there's no liability, which seems to be what your argument makes.
yes, if the liability crystallises at the point of disposal, then there is no liability in that year. And to come back
No,
to
but if it crystallises in the year of exit, but there's a deferment of actually having to pay
yes,
until realisation, which is at least one possible.
one way of reading it, one way of doing it. But then we're back in the world of choices, my lord.
Well, then,
this is the problem with this
Then it
case.
goes back to that point, though, which is whether that seems to then go back to your ground one, which is whether this is the conforming interpretation which the FTT actually came up with, or indeed an alternative one along these lines, would be available.
Yes, indeed. And so it goes back to the nub of the submission about choices, which is that we're canvassing different ways in which this might be done. It might be right that the liability is in the year 04, 05, but the payment is later. I think that would be slightly odd, because even if you were to quantify it in 05, 06, the liability to pay would fall in the tax year of disposal. Certainly on my ordinary assumptions, it might well be possible to draft the mechanism by which the liability to pay is in 04, 05, but then it's deferred in some way. But all this goes to, my lord, is my core submission under ground one, which is there are many, many different ways of doing this. And the question for this court is this court, I don't want to put it too high, is this court constitutionally in the right place when it makes those choices? And in my respectful submission, it's not. And so, in that sense, it's a plea, as I say, for fidelity to the words that Parliament has chosen. And also, I'll come on to this in a moment, the words that Parliament chose when it did change the law arising out of this particular case. So it's absolutely right that if my clients succeed, they won't be liable to pay any capital gains tax. They don't shy away from that. They don't accept that there's anything improper or untoward about that. That doesn't answer the question in the case. It's also absolutely right that my clients could, in principle, have been made liable to pay tax in a lawful manner if the UK legislation had been different. And that's a point that's relied on against me. But it just begs the question raised by this appeal, which is, can the unlawfulness in the legislation be rescued by conforming interpretation? And the mere fact that tax might in principle lawfully have been charged is not in principle a reason to read back in an obligation to pay it. That's not, in my respectful submission, how statutory interpretation works or should work.
Can I just flag up a point, please, Mr. Johnson, which is that I'm slightly concerned about the difference between Section 3 of the Human Rights Act and Section 2 of the European Communities Act 1972. And at some point, I'm hoping you're going to explain how your argument is consistent with the language of Section 2 of the 1972 Act.
Absolutely, my lady. I wasn't proposing to take you to it specifically, but I was proposing to take you to
Isn't it crucial to the case? Because that's where the obligation to come up with a conforming interpretation comes from.
Well,
it's not a power, it's a duty.
It's a power to either come up with a conforming interpretation or to disapply if no conforming interpretation is possible. So that's.
I think the language of Section 2 is very important.
Well, I will address you. I will absolutely address you on that after the short adjournment and take you to it.
I don't want to take you out of your.
No, I'm grateful.
That up.
So the fifth and final part of the picture is to look at what the law says now. And so for that, can I take you to the Supplementary Authorities Bundle and to tab 1 of that? So this is the legislation that was passed in 2019, in response to this case, my case, as a direct result to it. And it starts at page 2 of that bundle. And just to talk through it briefly, it's a schedule to the Finance Act of 2019. It inserts a new schedule into the Taxes Management Act, Schedule 3ZAA. As you can see, this schedule makes provision for certain persons who are liable to pay an exit charge under Section 25 or 80, that's us 80 of the 1992 Act, to pay HMRC the charge in instalments. Then we have the eligibility provisions in paragraph 2. This paragraph applies where a person resident in an EEA state outside the United Kingdom is liable to pay an exit charge for a year by virtue of those provisions. Indeed, actually, we need to go through, my apologies, to the next paragraphs 1 and 2. That deals with companies. Paragraph 1 on page 3. This paragraph applies, you can find it's just above the first hole punch, where the relevant trustees of the settlement are liable to pay an exit charge for a tax year by virtue of Section 80. The relevant trustee is eligible to enter into a CGT exit charge payment plan in relation to one or more of the assets to which the exit charge relates if, and here are the eligibility requirements, at the time the trustees of the settlement ceased to be resident in the United Kingdom for the purposes of that section, they had a right of freedom of establishment. B, immediately before that time, the trustees of the settlement used the asset or assets for an economically significant activity in the UK. C, immediately after that time, they became resident in another EEA state and used the assets for economically significant activity carried on there. Para 4, the CGT exit charge payment plan may relate to the whole of the exit charge or only part of the exit charge. Then para 5, a CGT exit charge payment plan must provide for the deferred exit charge to be payable in 6 equal instalments, where the first is on the day on which the payment of the exit charge is due and the other 5 in anniversaries. 6, this is key, to enter into a CGT exit charge payment plan, the taxpayer must apply to HMRC, and HMRC must agree in 3B to accept payment in accordance with the plan. 7, contents of the plan. The only thing to pick up here is little 4, sub 4. A CGT exit charge payment plan may contain appropriate provision regarding security for HMRC. If appropriate, effect of the plan in para 8. The deferred exit charge, little para 4. The deferred exit charge carries interest in accordance with part 9 as if the plan had not been entered into. 5, and this is we say really significant, the taxpayer is liable to penalties for late payment of the deferred exit charge only if the taxpayer fails to make payments in accordance with the plan. See item 3C of the table at the end of paragraph 1 of Schedule 56 to the Finance Act. And actually over the page you'll see that section, item 3C, is an amendment. So it is necessary, just to capture why, it's necessary to amend the rules on penalty payments, otherwise you would be making a late payment, and so you have to add in another exception in relation to penalty payments in order to make the mechanics of this work. So it's not just this schedule, it's the consequential amendments that go with this schedule too. 9, for the purposes of any double taxation arrangements, a person is treated as at any time resident in a territory other than an EEA state. The person is also to be treated as resident there at any time for the purposes of this schedule. So again, we're dealing with the possible further consequences that lie outside. Turning over to main para 3 of this schedule. This is where we get 3C added to the penalty provisions. And then finally, on page 7, we rely on the commencement provision. I'm going to come back to this. But the amendments made by paragraphs 1 and 2 have effect in relation to amounts of capital gains tax which the person is liable to pay by virtue of Section 80 in relation to events occurring on or after 6th April 2019. Just to foreshadow my submission, which I'm going to be taking by reference to another authority of this court, the fact that Parliament itself has taken a view as to the temporal scope of this scheme, we say, is relevant to the question before this court about whether it can and should read in a scheme. And for the avoidance of doubt, of course I anticipate that conforming interpretation doesn't need to be quite in the form of words and full words of this. I fully, squarely accept that. But the effect of what the Upper Tribunal found is remarkably close to this schedule. And Parliament decided, when introducing this schedule, not to give it any retrospective effect. So 3 very brief submissions in relation to that. The conforming interpretation by the court, as I say, is very similar to this, and we do say that that is telling, and it's telling as regards the principle I'm going to take you to, possibly this morning, possibly after the short adjournment, that conforming interpretation may not be relied on to make a scheme. And we say this is a scheme. Second, you see from the scheme itself that there are knock-on consequences that follow from it. The obvious example is the provision in relation to late penalties. This isn't a peripheral point. It goes to the question of conforming interpretation. It goes to the question whether or not it's possible to drop in, by way of conforming interpretation by the court, a scheme without recognising all of the roll-on consequences that would need to follow from it. The truth is that... Is
that one of your grounds of appeal? I don't remember seeing that.
No, it's a submission about the nature of the scheme.
But there isn't a ground of appeal saying that the conforming interpretation that the FTT came up with doesn't work.
No, and I'm not saying it doesn't work. I'm saying the conforming interpretation that the FTT has come up with must have embedded within it, I think, a series of further consequences that may not have been adverted to by the FTT. I'm not saying that the FTT was wrong in this respect. I'm simply making perhaps a slightly more humble point, which is that a scheme of this kind is a scheme that has consequences that go beyond just the simple articulation of we're going to do this in 5 equal stages. So it's a more, as I say, it's a more humble submission than that, my lord. Third, critical submission. This scheme reflects the outcome of parliamentary decision making. There are choices made here in relation to, at least, A, the nature of the deferred payment scheme. It could have been, as we know, by reference to the date of realisation of the asset. B, the number of payments that may be made over time. We know, and we'll see from the case law, there are options there. C, the conditions under which parties will be eligible. We saw a provision as well about security. Just to anticipate my submission, that's a function and a task that's reserved to Parliament. And in my submission, what the Upper Tribunal has done in this case is to usurp that function. And when we see it, we'll come to it shortly, the Upper Tribunal described the making of this scheme as something that only Parliament can do because it required Parliament to make choices. And that's paragraph 150 of the judgment. And we agree. The question is, in those circumstances, how it is that the Upper Tribunal decided that nonetheless it could find the conforming interpretation that it found in this case. Fourth, it's the point I've already made, Parliament could have but didn't give this provision retrospective effect, and the court will be slow to step in and give it a different temporal scope when Parliament has decided it will apply from 2019 onwards. So that's the close of my introduction on the factual background and context. That leads me to my third heading, which is the law. 2 areas here to cover. Firstly, exit charges in EU law, and secondly, conforming interpretation in domestic law. And I hope to cover the first part of that reasonably quickly, because you've already seen the reasoning of the Court of Justice in this case, but 5 things to take from the authorities. And the first of those is from National Grid Indus, which is in the authorities at tab 88, at page 2905. This is a case about a company moving from the Netherlands to the United Kingdom. On their departure, they were liable to an immediate payment of tax in relation to an unrealised exchange rate gain. And the question was whether the imposition of such a tax liability interfered with the freedom of establishment. And we'll find the answer at paragraph 37 on page 2886. This is the Advocate General, which is followed by the court. I therefore propose that the reply to the first question should be that a company may rely on the freedom of establishment guaranteed by...
I'm sorry, you're on 2886?
2886 at paragraph 37. I'm sorry.
37, thank you.
The answer to the first question should be that a company may rely on the freedom of establishment guaranteed by Article 43 against the member state under whose law it was incorporated if that member state imposes a final settlement tax on the occasion of the transfer of the company's place of effective management to another member state, in the sense that corporation tax is payable on the capital gains which have accrued up to that date but not yet been realised on the assets transferred without deferment and without the possibility of future losses being taken into account. So the unequivocal conclusion, this is the first starting point, is that exit charges of this kind interfere with the freedom of establishment. That's plank one. Second, if I can take you to Authorities tab 85.
That's the Advocate General.
That's the Advocate General, yes.
Not the court.
If you want the court, my lord, that's at 2905 at paragraph 37. In the case, in the main proceedings, it's clear that a company incorporated under Netherlands law wishing to transfer its place of effective management outside Netherlands and the exercise of its right guaranteed under Article 1490 of the EU is placed at a disadvantage in terms of cash flow compared to a similar company retaining its place of effective management in the Netherlands. In accordance with the national legislation at issue in the main proceedings, the transfer of the place of effective management of a Netherlands company to another member state entails the immediate taxation of the unrealised CGT, the capital gains relating to the assets transferring the place of management within the Netherlands are not taxed until they're actually realised, and to the extent that they are realised, that difference in treatment relating to the taxation of capital gains is liable to deter a company incorporated under Netherlands law from transferring its place of management to another member state. Second key proposition from Authorities tab 85. This is a case called N, and
that's dealing with sort of one-sided balance, which is the question of whether it's interfering with the right of establishment.
Yes.
Freedom of establishment. So just looking ahead, it looks like the court then has a section called justification.
So, and I'm going to, you take me on to exactly my second point, which is that measures of this kind can, in principle, be justified. And for that, I was going to take you to N and the inspector at paragraph 46. Thus, gains realised on the disposal of assets are taxed in accordance with Article 13.5.
I'm sorry.
Oh, I'm very sorry.
The curve, we are at Authorities 85.
85, paragraph 46, which is at page 2759. My apologies, my lady.
Thank you.
So thus, gains realised on the disposal of assets are taxed in accordance with Article 13.5, and in particular in accordance with its 2005 version, in the contracting state of which the person making the disposal is a resident. As the Advocate General has observed in paragraphs 96 and 97 of her opinion, it is in accordance with that principle of fiscal territoriality connected with a temporal component, namely residence within the territory during a period in which the taxable profit arises, that the national provisions in question provide for the charging of tax on increases in value recorded in the Netherlands, the amount of which has been determined at the time the taxpayer departed. And if we go on, just so you know what was decided in that case, well, actually, let's go to paragraph 47 over the page. It follows first that the measure in question in the main proceedings pursues an objective in the public interest, and secondly, that it is appropriate for ensuring the attainment of that objective. So the key point, the second central plank of the reasoning in these cases, is that it is absolutely lawful to charge an exit tax at the point at which a person, a trust, a company exits the jurisdiction. And that is in pursuit of the principle of fiscal territoriality. So there's no issue between the parties as to that. So you have an interference, you have an in principle lawful objective, and that's why, going back to my Lord's point, much of the case law turns on the question whether the measure in question is proportionate. Is it a proportionate means of achieving that end? And in N, you can see in the next page, we just looked at 47, paragraph 55 at the bottom of 2760. The answer to the third and fifth questions must therefore be that Article 43 must be interpreted as precluding a member state from establishing a system for taxing increases in value in the case of a taxpayer transferring his residence outside the member state, such as the system at issue in the main proceedings, which makes the granting of the deferment of the payment of that tax conditional on the provision of guarantees and does not take account of reductions in value capable of arising after the transfer of residence by the person concerned and which were not taken into account by the host member state. So the answer here is, in this particular case, yes, it's an interference. Yes, it might lawfully in principle be done. Is it proportionate? No, in this case, because in this case, in all circumstances, there is the requirement for a guarantee. It's a deferral until disposal provision, and it doesn't take into account the change in value of the assets. So you can see there the three steps, if I can put it that way, my first, second, and third point in terms of the logic of the court's case law. If I could take you over to Authorities tab 92 now. This is Verda Labtech. This is a case about charging CGT on a company transferring from Germany to the Netherlands. And if I could ask you to pick it up at 3016, paragraph 45. 3016, paragraph 45 in tab 92. Besides, member states entitled to tax capital gains generated when the assets in question were on their territory have the power, for the purpose of such taxation, to make provision for a chargeable event other than the actual realisation of those gains in order to ensure that those assets have been taxed. So this comes back to this question of the different ways in which this might be done. And what we have here is the question, can you do it by a means other than deferral until realisation? Answer from the court, yes you can. If we move down to paragraph 49, as regards the recovery of such a tax, the court has held that it was appropriate to give the taxable person the choice, we underline choice, between on the one hand immediate payment of the tax and on the other hand deferred payment of that tax, together with appropriate interest in accordance with the applicable national legislation. Paragraph 51, in the present case, the question therefore arises whether a staggered recovery of the amount of tax at issue by 10 annual instalments may be a proportionate measure to attain the objective of preserving the allocation of taxation powers. In that regard, suffice it to note that the recovery of tax on unrealised capital gains tax spread over 5 annual instalments instead of immediate recovery was considered to be proportionate. A staggered recovery over 10 can only therefore be considered to be proportionate as well. So what you have arising from that is the variety of different schemes that different member states have operated, some 10, some 5, some for deferral until the point of realisation. It's fair to say that, at least as far as I'm aware, whether or not you could do it in 3 or 4 years has never been tested with the Court of Justice. All we know is that 5 is proportionate. We don't know anything further than that.
I'm so sorry to interrupt again, Mr. Johnson.
Of course,
I missed the tab reference for the authority you've just been looking at.
I'm so sorry, my lady.
No, I was taking note about something else. It's my fault entirely.
It's tab 92.
Tab 92. Thank you very much.
And fourth, just to close the loop on the choice point, which is necessary for my ground 2, can I take you back to the core bundle and to the Attorney General's opinion in this case? Core bundle, tab 22, page 388, paragraph 55. I think this actually was a paragraph that I took you to earlier as well. I hadn't planned to, but I thought I would do it as I went past. But the court has already held on a number of occasions that the taxable person must have the choice. And so you see that there. You've seen that as well in Verda Labtech. And the same wording in the judgment over the page at Core Bundle tab 23, page 405. Paragraph 55. near the top of the page. Yes, sorry, it's 57 as regards last. And if you go over to the top of page 405, further legislation in a member state which provides that a trust which transfers its place of management to another member state may choose between immediate payment of the tax due on those capital gains or deferred payment of the tax. Now, I won't, because of time, take you to a number of other authorities where precisely the same point is made, but this is an absolute kernel of this case law, and you've already had my submission on why we say that makes this case different and more challenging for the revenue when it comes to the question of retrospectivity and my ground 2 in particular. Moving on to conforming interpretation in UK law. 4 introductory points. First, I think I can take my leasing from my skeleton. That's at core tab 16, page 23. It's not page 23, it's paragraph 23. Page 295, the Mar leasing principle is as follows. In applying national law, the national court, called upon to interpret it, is required to do so as far as possible in light of the wording and purpose of the directive in order to achieve the result pursued by the latter and thereby comply with the 3rd paragraph of Article 189 of the treaty. And of course, the words that we underline in that phrase are as far as possible.
Can I just ask a question about that?
Indeed.
Mar leasing is a case about complying with a directive.
Yes.
This is not a case about complying with a directive. This is a case about complying with one of the fundamental freedoms. Do different principles apply to those 2 different types of cases?
So the answer to that is, I think, in 2 or 3 parts. The first answer to that is that the obligation to identify a conforming interpretation as far as possible is something that the authorities have established applies both as regards, in this case, the implementation of a directive and more generally. The second part of the answer to that question is that whether or not a conforming interpretation may be identified may give rise to a different answer as between a case where Parliament has intended to give effect to a directive but has erred, if I can put it that way. I don't mean that sort of in a constitutionally proper way. The drafting has failed adequately to capture the directive. And I'm going to come on to address this further in a moment, but just to capture it now, in a case of that kind, it is much, much easier to know what Parliament intended. Parliament has sought to give effect to a directive, and it transpires that, despite its best efforts, it's failed to do so. And in that case, then the question, what's the grain thrust of the legislation, what's the intention of Parliament, is relatively straightforward. Not necessarily always possible, but certainly considerably easier than a case of this kind, where the starting point is that the legislation should, where possible, be given a conforming interpretation, but it was no part of Parliament's intention to establish a scheme for deferred payment of capital gains tax on departure. Parliament was not seeking to give effect to EU law. What's happened is that it has transpired that the legislation is not consistent with EU law. And so whilst the overarching Mar leasing approach is the same, the outcome may very well be different as between those 2 cases. And that's because when you come to a number of the different cardinals of the case law, whether it's going with the grain and the thrust of the legislation or identifying Parliament's intention or whatever it might be, the court is on much, much safer ground, where it knows what Parliament was intending to do, but it transpires that Parliament inadvertently didn't manage to achieve it. Where we know Parliament was not intending to achieve that because it was no part of Parliament's thought or apprehension at the time at all, then it's much more difficult, not always impossible for the avoidance of doubt, but it's much more difficult to be confident that you can find a conforming interpretation that you can lawfully read into the statute. So I suppose my answer is a sort of two parts, yes and, if that makes sense, my lady. Is that helpful?
Yeah, that does make sense. Can I just ask a follow-up question, please? Are any of the authorities in the bundle, the domestic authorities,
Yes.
concerned with a case in which what was at issue was a treaty right as opposed to transposition of a directive?
Let me have a think about that question.
Well,
I might answer it as I go.
I haven't had time to read every single authority in the bundle, so I just
Yes.
want to know what the answer to that is in due course, please. But
Yes. No, I will.
don't feel obliged to answer it now.
No, I understand entirely what the question is asked, and I'm very grateful, and I will, if not before the short adjournment, then after the short adjournment.
Don't worry,
I'm very
rather
grateful.
the answer carefully researched than off the cuff.
So that's the first introductory point in relation to conforming interpretation, which is to pick up on my leasing and the obligation there. The second is just to touch on the EU law authorities on this point. I'll deal with this very briefly. For that, we can go to the judgment of the Court of Justice in the Popel case. That's at Authorities tab 94. This is a case about whether a person who'd moved from one member state to another lost their rights to a pension on the basis that they were a civil servant but they moved to another jurisdiction. Did they lose a certain element of their civil service entitlement? And the key passage is at paragraph 43 to 45. And you'll find that, so it's behind Authorities 94, page 3075. And actually, maybe easiest if you read 43 to 45 and then I make my submissions in relation to them. So there, sorry, wait a moment. So what we have there, paragraph 43, the principle of effectiveness requires national law to be construed in a manner in conformity with EU law. Paragraph 44, there are limits to this, and the obligation on a national court to refer to the content of EU law when interpreting domestic laws of domestic law is limited by general principles of law and cannot serve as a basis for an interpretation of national law contra legem. 45, if an interpretation of national law in conformity with EU law is not possible, the National Court must fully apply EU law and protect rights which the latter confers on individuals, disapplying, if necessary, any provision insofar as application would lead to a result contrary to EU law. So what you have there is the principle, the limit, and the what happens if we get to the limit.
I'm so sorry to interrupt again.
Not at all.
The logical sequence there is you first of all ask whether there's a conforming interpretation.
Yes.
And only if there isn't, do you disapply.
Yes. So my lady, the starting point is to ask, can we, within our canons of interpretation and within our domestic law principles, and EU law is very light, unusually perhaps, light to touch on this. It says this is sort of a question for national law. But it recognises that there will be circumstances in which it is simply not possible to read domestic law in a manner compatible with EU law. And it gives the example of it being, or use the language of it being contra legem. And so it says, those circumstances, we move to disapplication. What one doesn't do in that circumstance is say, well, we're just going to apply it anyway, for obvious reasons. And the critical question raised by this appeal is whether or not we are at or beyond these certain limits identified in paragraph 44. As you know, it's my submission that we are. The third point is, and this I don't think is contentious, I'm mindful that my lady's asked me about it, so maybe I can address it more fully at a later point if you want me to. I'm proceeding, at this point at least, on the premise that it's agreed between the parties that the authorities in relation to conforming interpretation or disapplication, if I can put it that way, under sections 3 and 4 of the Human Rights Act, 1998, are applicable by analogy to this exercise. And for that, I was going to take you to Core Bundle tab 16, page 297 of my skeleton, and footnote 2, which refers to authority for that proposition. It says, this is footnote 3, it's well established that the principles applicable to disapplication and compatible construction under the Human Rights Act apply equally to our leasing principle and its boundaries. See the speech of Lord Steyn in Gaidan and Godin Mendoza. So that was common ground below. It was accepted by the tribunal below. I don't think it's an issue between the parties on the skeletons, but I'm mindful that Melody's asked a question about it. Are you looking for more detailed assistance on that point? And in particular, is there a question underlying it, or a?
Well, yeah, there is a question underlying it, which is that, just in outline, the structure of the Human Rights Act is designed to preserve parliamentary sovereignty. Yes. Whereas on, I think, any view, yes, Section 2 of the 1972 Act explicitly does not do that. So that's just a point that's worrying me. It may be that we're bound by authority, which says we apply the same approach, but that's what I'm getting.
No, I understand entirely the question, and I think at least my first run at an answer contextually to the question would be to put it this way, which is to say that it's right that the Human Rights Act provides a very carefully crafted mechanism by which, where there is, where conforming interpretation is not possible, parliamentary sovereignty is recognised by the declaration of incompatibility as regards which Parliament may do what it wishes in principle, albeit ministers normally have to come to Parliament to answer as to what they are doing. So there's a careful constitutional propriety and balance struck there. You're absolutely right that Section 2 of the European Communities Act takes a different approach. And the different approach, if I can put it this way, is in the Section 4/disapplication end of the party, which is that, of the process rather, which is that rather than making a declaration of incompatibility under Section 2 of the European Communities Act, this court is entitled to disapply. And we've seen that from the Popple judgment. And so where one gets to at the end of the conforming interpretation exercise is different, which is that rather than saying, mindful of the constitutional balance between the courts and Parliament, we're going to make a declaration of incompatibility, under Section 2, you are empowered to disapply. And therefore, in that sense, you are empowered to go further than you would do under the Human Rights Act. But if anything, my submission, that's a point that goes in support of my client's appeal. Because what it says is that to the extent it might seem peculiar, awkward, or uncomfortable to say, we're simply not going to impose a charge to tax in this case, European Union law is, if I can put it this way, more comfortable with that outcome. This application is a part of the ordinary toolkit of EU law construction in a case of this kind. So that's where the difference lies, and that's why, in my respect for submission, the kind of kernel of the difference between them actually lies at the disapplication / section 4 part of the analysis. But in terms of the grappling with the conforming interpretation exercise itself, I think it's common ground that there is not that the cases as between the two areas are at least analogous, if I can put it slightly crudely, at the section 3 / conforming interpretation part of the exercise. The difference comes with what the consequences are, because in the same way in the Human Rights Act authorities, you get to the point where you simply can't do it. You simply can't find a conforming interpretation in a way which is constitutionally proper, and the answer is a declaration of incompatibility. And so the steps are similar. The terminus, if you can't find a conforming interpretation, is different. Fourth, and I hope this is picking up in part on your ladyship's question, the overarching threshold, the overarching test, if I can put it that way, and I'm going to unpack different ways in which it's articulated later, but the overarching test, as I've said before, is between interpretation and amendment. And we take that proposition from the case of R and Lambert, and its judgment of Lord Hope, and you'll find it at Authorities Bundle tab 37 at page 621. So this is a case in relation to the Human Rights Act. It's a case about whether or not, where the boundary lies between interpretation and amendment. It was a case about the burden in a criminal case, but the speech of Lord Hope is helpful on the boundary between the two. So if we pick it up at F on 621, the sentence that starts middle of the paragraph, I'm very happy if you want to read the paragraph above, but for my purposes I was going to start at it ought. It ought to be possible for any words that need to be substituted to be fitted into the statute as if they had been inserted there by amendment. If this cannot be done without doing such violence to the statute as to make it unintelligible or unworkable, the use of this technique will not be possible. It will then be necessary to leave it to Parliament to amend the statute and to resort instead to the making of a declaration of incompatibility, so in the human rights context. As to the techniques that may be used, it is clear that the courts are not bound by previous authorities as to what the statute means. It has been suggested that a strained or non-literal construction may be adopted, that words may be read in by way of addition to those used by the legislature, and that words may be read down to give them a narrower construction than their ordinary meaning would be. It may be enough simply to say that the effect of the provision, what the effect of the provision is, without altering the ordinary meaning of the words used. In other cases, such as Vasquez, the words used will require to be expressed in different language in order to explain how they are to be read in a way that is compatible. The exercise in these cases is one of translation into compatible language from language that is incompatible. In other cases, as in R&A, it may be necessary for words to be read in to explain the meaning that must be given to the provision if it is to be compatible. But the interpretation of a statute by reading words in to give effect to the presumed intention must always be distinguished carefully from amendment. Amendment is a legislative act. It is an exercise which must be reserved to Parliament. So this is the expression or a clear articulation, those final sentences, that there is a threshold. Yes, you can read in words. Yes, you can read down words. Yes, you can provide a gloss to explain what the words mean. But there is a point at which the court is no longer construing and it is amending. And that is the point at which the court is obliged, in this context, to make a declaration of incompatibility, in our case, to disapply. So that's by way of introduction. I've set out in my skeleton argument 4 different tests. that might be used to identify the threshold between interpretation and amendment. With your permission, I'd like to touch on each of those now.
Before we leave, Lambert, can I ask a really nerdy question?
Of course.
I was just looking at the head note. Is all this stuff about interpretation overturn?
Well, let me see.
Because it just, I mean, I've just looked at the first bit of the head note, and it
The Appellant
seems
Jurisdiction Class A drugs.
doesn't apply to stuff happening before the date when it came into force.
Although the appeal was heard and judgment was given before the 98 Act came into force, the Court of Appeal proceeded on the basis that it was in force. It dismissed the appeal. How dismissing the appeal? Melody, you're absolutely right. So actually, you're right to say this is overturn. I think I'm right to say, and I will check, that this
It's probably being picked up.
is being picked up. I think it has been picked up and quoted, but you're absolutely right, my lady. That's not a nerdy point. That's absolutely a correct and helpful one. But in any event, it's very well established. I picked it out because it's a very helpful kind of encapsulation of the proposition, which is the threshold question for the court is: are we going beyond interpretation and into legislation? And what I propose to do now is to talk through 4 different tests that have been identified by the court as entitling, or as assisting in identifying that threshold. And the first of those is Fleming. Sorry, the first authority is Fleming, but just before I go to it, to identify the test itself, it's well established in my submission that the reading in of a scheme or a new structure into a statute that was not a part of the original act will be judicial legislation. So that's part of that's one of the tests, if I can put it that way. When one stands on the boundary between interpretation, conforming interpretation, and this application, part of the threshold test is: are we making a scheme? Are we reading in a new structure? So if we could start.
S minus.
S minus, exactly, my lady. And you understand exactly where I'm going, because that's one of the authorities that's cited at some length in my skeleton, and if I have time, I was going to pick it up as well. But just to start with Fleming, at tab 45, this is a case that requires a bit of introduction. There are several cases here on appeal to the House of Lords. They're in relation to the loss of an opportunity to claim for repayment of input VAT. So prior to the relevant statutory amendment, it had been possible to recover input VAT dating back 6 years. The government, by regulations, had removed that right and reduced it to 3 years. And the critical question before the court was a slightly unusual one. It was already established that the amendment without a transitional period was unlawful for the purposes of EU law. And what the court had to decide was whether the legislation could be made conforming by disapplication or reading in of a transitional provision. So it's a kind of, there are different ways that they might go through and find a solution. And the reason I say that is the question really was whether the new time limit should be read out altogether, back to Parliament. Parliament makes a transitional scheme. We know the transitional scheme is needed. It could be done in lots of different ways. Leave that to Parliament. Or whether or not a transitional scheme should be read into the Act to make it lawful. There's a very helpful summary of the issues in Lord Hope's speech at page 931, paragraph 6. I'll actually let you read that rather than reading it to you. So just to just to, firstly, because it helpfully sets up the context, but also secondly, just to knock on the head one of my learned friend submissions, which is that this case is completely irrelevant or is completely different because this is a case about disapplication. Actually, that's not the only question the court was asking itself. The question the court was asking itself was, do we read in a transitional scheme or do we disapply? So yes, it is a case about disapplication, but it is not a case which says nothing about conforming interpretation. On the contrary, in my submission, it's actually very much a case with very clear application in this context. And part of the reason for that is you can see the temptation, if I can put it that way, in paragraph 8. The decision in Grundig deals with the first situation. It tells us that the fact that the National Court has found a transitional period fixed by the legislature is insufficient does not necessarily mean that the reduced period for initiating claims cannot be applied at all. The National Court cannot apply the inadequate transitional period to claims made with regard to rights accrued before the entry into force of the legislation which introduced the time limit. But it is open to the court, as the ECJ did in that case, to make its own assessment of what is in accordance with EU law, to make an assessment of what, in accordance with EU law, is an adequate transition period during which the new time limit is not to be applied retrospectively. The reasoning in paragraph 41 shows that the ECJ was satisfied that the making of a relatively modest adjustment to the prescribed period was not inconsistent with the principle of effectiveness. So what's interesting and important about this case is here they're explaining that it is clear in EU law that they know what would be a lawful transition period. But then we get the very clear conclusion of Lord Hope in paragraph 10. I would not rule out the possibility in a suitable case of the court reaching its own decision as to what would be a reasonable time for the making.
Well, it wasn't just, I'm sorry to pick you up.
Not at all.
Isn't 8 dealing with the situation which was not before them? And then he goes on in 9 to deal with the situation which is before them.
The other situation is that which applies in the case of the two appeals.
So that he describes two situations in 7. 8 deals with the first, which is where pre-existing time limits have been
amended.
And then he says the other, in 7, which is this case, is where there was originally no time limit at all, and no transitional arrangements are being included. And then in 8, he's saying Grundig deals with the first, and then in 9, he says, well, we're now in a different situation.
We're in a different scenario.
So I'm not sure he is saying that
we know the answer.
Grundig tells you the answer to this case.
But that's very helpful, my lord. What he does say in 9, and I'll go away and have a careful read over short agenda, but what he does say in 9 is that this will not be in breach of EU law so long as transitional arrangements are included which allow an adequate period for the lodging of claims which persons are entitled to submit under the original legislation. So what they do know in this case is that it would be rendered lawful by a transitional period.
Yeah.
And so that's the kernel of the issue before the Lordship's House, which is, given that you know that a transitional period is necessary to make this lawful, the invitation was, well, we'll make it lawful by way of conforming interpretation by reading that in. And that's where we get to 10. And in fact, if you read at the end of 9, unless this is done, there will be a breach of the principle of effectiveness. I would not rule out the possibility in a suitable case of the court reaching its own decision on what would be a reasonable time for the making of claims and rejecting claims that were made after a period which it held to be reasonable. But I do not think that the situation disclosed by these appeals lends itself to that treatment. In my opinion, this is a step too far for a court to take. The issue is not one of statutory interpretation for which the court must accept responsibility. There is a gap in the legislation which is unfilled. And we underline that sentence. The infringement of EU law in this respect cannot be said to have been comparatively minor or inadvertent. The primary responsibility for giving a clear indication to taxpayers as to where they stood in regard to the making of claims, despite the retrospective introduction of the time limit, lay with the legislature and the executive. So what Lord Hope's saying in this really quite short judgment of 12 paragraphs is, there's a there's a void in the statutory scheme. I'm being invited to fill that gap, and I decline to do so because I should not do so. That is not the function of the court. If we turn over to the speech of Lord Scott, paragraph 21, which is on page 936, it is argued alternatively that the court can and should fix the duration of an extra period, a transition period, that must be allowed to claimants whose pre-1st May 1997 claims would otherwise be barred. It is to me a surprising proposition that the court can, by judicial legislation, add a transitional period in order to cure the invalidity of a statutory provision that would not otherwise comply with European law and be enforceable against certain claimants. There are, to my mind, several objections to the proposition. First, it's not the function of judges to legislate. Second, the principle that people must be expected to know the law and conduct their affairs in accordance with the law can hardly apply to a judicial amendment to primary or secondary legislation. That, until it is made known in the judge's pronounced judgment, is held in pectore. The objection to retrospective legislation would apply here too. Third, the important principle of certainty can hardly be satisfied. The terms of the judicial amendment can change as the case travelled up the appellate chain. And we do say that is pertinent in this case because the terms of the judicial amendment, I mean, there's a complicated question about whether interest was within scope or not in scope for the Upper Tribunal. Mr. Margolin's going to deal with that question, but we are in precisely that case as regards interest. Precisely what the conforming interpretation has changed as between the first tier tribunal and Upper Tribunal in my case, and the ability of this House to depart from previous decisions would have to be taken into account. And then if we turn over just to the paragraph, the last paragraph of Lord Scott's, again, admirably brief judgment on 937. My lords, the ECJ in this passage was dealing with the principle of effectiveness, but that's not the only principle in play. The principle of certainty, too, must be taken into account. Taxpayers are entitled to know from the statutory scheme what input tax repayment claims they can bring under 29. In the absence of any such statutory transitional provision, how are they to know? And so on and so forth. It is no answer to the requirement of certainty to be told that the claims can be brought within an adequate transitional period. There is also the constitutional point, which may or may not apply to judges sitting in Italian courts. It's the function of judges sitting in UK courts to construe primary and secondary legislation. It is the function of judges sitting in UK courts to disapply UK legislation that is inconsistent with community law. It is not the function of judges sitting in UK courts to amend UK legislation that is inconsistent with community law. And that is why, if I can put it sort of tersely, my appeal is the black letter appeal, which is to say that this is a case where there's a gap, you're being encouraged, read in a scheme, and actually the scheme to be read in here would be considerably simpler. It would probably just say the transitional period, there should be a transitional period running from date X. The House of Lords is absolutely not. We're not prepared to do that. That is for Parliament. That's the making of a scheme. One more passage, if I may, from Lord Neuberger, in page 958. Paragraph 85. On that basis, given that Regulation 29(1)A came into force on 1st May 97, people with accrued rights to claim input tax as at that date would have had to put in their claims by 1st May 98 at the latest, so one reaches this position. The vice in the regulation is that it contains no transitional period to enable a person with accrued rights to make their claims, and the remedy on the Commissioner's case is that there is to be a period of disapplication whose existence would be unknown to any reasonably well-advised person with an accrued right until it had already expired. That would mean that the supposed remedy for the failure to accord a transitional provision would be little more than hypothetical. And it's worth saying, this is where part of the reason why, to sort of tie the chain together, I've been stressing the question of choice, the option to choose. And the fact that the option to choose must not be purely hypothetical. And that's what Lord Neuberger is saying here. Nobody could have apprehended it at the relevant time. It would have been a purely hypothetical entitlement.
What do you say the accrued right was in your case?
The right in my client's case is the right to freedom of establishment which has been unlawful, which is interfered with by the exit charge tax in a manner that is unlawful. That's their right. Their right is the right to move, as Mr. Panayi did, back to Cyprus, to his country of birth, without being subject to a scheme of taxation that discriminates between him and if he had chosen to move within the United Kingdom. That's his right. That has been unlawfully interfered with. There's no issue before this court that it has been unlawfully interfered with by the legislation. The Revenue's case is that you should remedy that by way of a conforming interpretation. Now, Mr. Margolin will address you on this. A conforming
one view is that the right you're saying you had was because you've accepted that it could have been the case that the UK had a statute which said that there was an option to defer.
It could have been the case. I think the way I would put it was, had the United Kingdom had a statute of that kind, then it would have been lawful. I don't say it's never lawful.
It would not have been contrary to EU law.
Yes.
And the EU authorities say that a provision which says tax can be charged but deferred is capable, at least, of not infringing the right
yes.
that you refer to.
Absolutely.
So it could be said that the right is, another way of looking at it could be that under EU law there could have been a right to either pay the tax or defer it.
There are two rights that are critically in play.
In fact, it really is a liability to pay tax. It's just a liability to pay it in different ways.
So the rights are firstly the right to move without unlawful interference, and secondly, the right to choose. If there is to be a scheme that is lawful at all, it must involve choice. So the EU law says two things. It says, firstly, one can in principle do this, absolutely, principle of territoriality. Secondly, that will only be lawful if the taxpayer is offered a right to choose at the point of departure. And so that's where my ground two bites in my respectful submission, because very plainly there wasn't a right to choose. And in fact, and Mr. Margolin's going to address this further, the very idea that you would defer in stage payments of this kind wasn't even articulated in the case law at the point at which my client departed. So
it was a right to choose how to pay a liability.
Yes.
I mean, what they're talking about in this case is people actually being deprived of an accrued right to reclaim input tax.
Yes.
They're actually losing out, as it were, because these new provisions are coming in, and there's a period in respect of which people didn't know about. Suddenly, they're not able to reclaim the tax.
Yes.
Your case is one, or this case is one where the question really is about what the obligation to pay would have been. Would it have been in one go or over 5 years?
So,
I mean, I know I'm jumping ahead, and there are lots of stages in that. So don't take it that I'm suggesting this is the only point, but this is one way of looking at
absolutely
things.
And part of this goes back to the point that I addressed right up front at the beginning, which is that the Revenue's case is that what you're seeking to do is turn a right to pay in stages into a right not to pay at all. And at its core, my answer to that submission is it just begs the question raised by this appeal. My client's appeal is on the basis that A, we know the law was unlawful at the relevant time. B, the question is, can this court, by conforming interpretation, make it lawful? And so therefore, if I can put it this way, characterising the nature of the appeal as, and that's why I sort of slightly glibly said, well, we can criticise their evolving case, they can criticise my client for being unprincipled and seeking to pay no tax. But I think in a funny way, both of those are ancillary to the core point. And the core point for this court is, given what we know, which is that the scheme for payment of tax is unlawful, can you in 2026, sitting in this court, take the Taxes Management Act and make it lawful in this way? and whether or not that involves what might be characterised as a windfall, and whether or not it's slightly different to Fleming, because in Fleming there's an accrued right to declare, and in this case there's a right, freedom of establishment and the right to choose. In a funny way, those points are significant only in that they still lead you ultimately back to the critical question for the court to decide, and that is, what is the boundary of conforming interpretation? And so I don't disagree that Fleming is...
the Rubicon point.
Indeed, I don't disagree that Fleming is different on the facts.
Yeah.
I suppose my point is that Fleming is squarely on all fours on the principle. And that's where, if I can put it that way, that's where I sort of plant my flag analytically by saying the House of Lords was being asked, look, can you know what you need to do, put in a transitional period and it'll be fine. And the judgments are pretty forceful on that question, actually, saying that's absolutely not our function.
But I don't think there'd been a decision of the European Court in that case saying a transitional period of 2 years, say.
So
it's good, and a transitional period.
No, but they were aware that a transitional period was a transitional period of some kind would be lawful.
Yeah. But then
they would
have had to decide, should it be 2 years, 1 year, 3 years?
And again, I mean, you apprehend exactly what my submission is going to be, my lord, which is that partially the revenue takes the benefit of this case having taken 22 years, so that we're now in a position where we do have all of these judgments of the Court of Justice. But even in that circumstance, actually what the Court of Justice has said is not, here's the answer. The Court of Justice hasn't said, this is what EU law requires, it's this form, or that is the least amending form or the least intrusive form or the best fit. The Court of Justice has said, look, you can do this loads of different ways. You can have 5 years, you can have 10 years, you can have deferral until you pay the asset is disposed of, as we canvassed earlier. That might take different forms as well, about when the liability arises and so on and so forth. So that goes straight to my second kernel, which I haven't quite got to, which is choice. I was going to address you briefly on the case of Routier.
I was just going to say that all of this boils down to 2 points, doesn't it? One of which is there's a gap which is not for the court to fill.
Yep.
And secondly, even so, if you were to insert a transitional period, that would not be open to your client to use, life and time having flowed under a very long bridge.
Indeed.
And therefore it doesn't work. That's all you're saying.
And I apologise if I'm over elaborating, my lady, but you do capture a core part of the kernel of the case. Very briefly, I might take Anderson from my skeleton. I won't go to Routier. I think Mr.
No, I'm sorry, I interrupted you.
Not at all.
You were going to Routier.
No, I think I won't. I'm mindful of the time. Mr. Margolin and I have discussed that in certain circumstances he might pick up Routier in any event. Just to capture it very, very briefly, Routier is a case where the Court of Appeal, A, knew what it needed to do to fix the problem, B, came up with a solution, which is all a case about inheritance tax, transition to Jersey, and so on and so forth. That goes to the Supreme Court, and the Supreme Court says, absolutely not. You're absolutely right to say, here's the breach of EU law and here's how it could be remedied, but it's not for us to do that. And my learned friend's answer to that is to say, well, just don't worry about Routier, because Routier is a case which is all about a judicial gloss on a statute. And we say that makes no difference at all. A judicial gloss on a statute tells you what the statute means. The question was, do we disapply what the courts have said the statute means? And so we have a statute, we know it means A. The question is, do we read in a mechanism to work around it or disapply? And the Supreme Court says, we disapply.
Wasn't the Supreme Court just saying there's a really, really simple solution here? Because the only reason why there might be incompatibility is because of a judicial gloss on the statute. Ignore the judicial gloss and you're left with the statute, which then is then in conformity with EU law. So you don't need to go through the mental gymnastics of going around the houses. You just say, read the statute according to its non-glossed words. In other words, you don't add anything into the statute, and hey presto, it complies with EU law.
So I've done the thing that advocates should never do, which is say I'm hardly going to address you on a point, then raise it, and then make Mr. Margolin's life
It's just
a nightmare. But he at least
like taking a shortcut between 2 points. You can either go a very long way round, or you can take the straight line.
But so you're right, my lord. That is, if I can put it this way, the superficial attraction of the outcome, which is that it's a simple outcome. The way disapplication, we're disapplying the statute as it has been understood. We're changing it. The judicial gloss is one way of saying that is what the statute means for the present time. I will leave it to Mr. Margolin to address you further if he wishes to do so. But the kernel of the point is that the Court of Appeal reads in an answer that says, if you're moving to an EU member state and you're doing this, then you'll be relieved from this obligation. The Supreme Court says that's not what we should do. They don't just say this is an easier solution. They disagree with the methodology, if I can put it that way. The final authority I will take from the skeleton very briefly, because it captures this first threshold distinction nicely. So that's from tab 16 of core, page 299. And this is Anderson, as glossed in Godin Mendoza, but the only reason I come to it is for two things. You'll see in the middle of the paragraph. It wasn't pure rhetorical flourish from counsel earlier to use the word Rubicon, because that is what the court itself has used in that context. And interpretation could not provide a substitute scheme. So it's just a very pithy encapsulation of that first principle that I say gives this court the imprimer of knowing where you're stepping from interpretation to legislation. So that's the first. The second threshold test is that the court shouldn't make policy choices reserved for Parliament. Two authorities here. First, Re S, which was the case referred to by my ladyship a moment ago. I understand the court's familiar with it, so I'll take it pretty quickly. This is a case about care orders in respect of children. The court had made a care order. The local authority failed to comply with the care plan. The Court of Appeal, a very distinguished Court of Appeal, decided that the failures of the local authority were breaches of the children's rights under the Convention, and so they read in a system of milestones into the care plan so that there might be a way of keeping track of the steps to be taken. If we could turn to page 713.
Sorry, which?
Of what?
Oh, sorry, it's tab 39. So I thought I'd mentioned the tab earlier. Paragraphs 35 and 36. And again, the point here made by Lord Nichols is he fully understands why the Court of Appeal would have wanted, given the particular facts of that case a fortiori, to read in a scheme and to make policy choices, but it's wholly improper to do so. If I can invite you to read 35 and 36, which are on 713 and over 714. And one facet of that, by no means the entirety of that proposition, about choosing one of the additional features we find at paragraphs 43 to 44, which is that making choices may, in some cases, have practical ramifications. And you'll find that at F, in paragraph 43. It would constitute amendment of the Children Act into its interpretation. It would have far-reaching practical ramifications for local authorities and their care for children. So one of the reasons that the court doesn't make choices is because of the practical ramifications, but there's also the kind of wider macro constitutional point that underpins it, which is that choices are reserved for Parliament. And I know that my ladyship, I won't send it up, it was referred to in the skeleton argument, the Ofgem and Pytel case. Again, that principle is referred to and relied on there, the practical ramifications being things that the court cannot and should not choose between. The third threshold test concerns whether the conforming interpretation will offend against the principle of legal certainty. just to clear some ground here, all conforming interpretations are retrospective. They declare what the law always was. And so in many cases, this is not a problem. But a conforming interpretation may not give rise to what is a hypothetical entitlement or a right that could never have been exercised. And I've already shown you, so I won't take you back to it in Fleming, Lord Neuberger referring to the right as hypothetical, Lord Scott, in the paragraph I showed you, effectiveness is not the only principle in play, the principle of certainty too must be taken into account. So what I want to do finally on this part of the law is to show you the application of these principles in a variety of tax cases, and also to deal, if I have time, with a couple of authorities relied on against me. There are a considerable number of tax cases where conforming interpretation has not been possible, and so the only and inevitable solution has been this application. One of those is FII. So if we turn to Authorities tab 68, page 2094. So this is from the head notes, just to give you, at G, you have it there, just to give you a very, very brief insight into the factual context of this very complicated case. At the heart of the FII GLO were claims for restitution arising from the differences between the tax treatment of the claimants which had received distributions from subsidiaries resident outside the UK on the one hand, and the tax treatment of UK resident companies which received distributions from their UK resident subsidiaries on the other. That differential treatment resulted in the levying of taxes that were unlawful under UK law. So if your Danish subsidiary pays you dividends, you pay a disadvantageous tax as regards to that than you would if it was a UK subsidiary. And that's the core of the issues. There are a number of issues that the Supreme Court decided. Just turning forward to page 2134. Paragraph 143. Just below the citation from EU law, having regard to those qualifications, there is a question which this court need not answer. So again, this is obiter, but I do nonetheless rely on it as an indication of how this should be done, as to whether the words "the total profits" where they appear in section 75 of ICTA could in any event properly be interpreted as meaning the total profits, brackets, excluding any income falling within case 5 of Schedule D. So that would be a conforming interpretation that would remove the problem, inverted commas, as regards the differential taxation. And the court says it's not prepared to do that. And we see in paragraph 145, in principle, therefore, the problem can be resolved by disapplying the domestic rule that the DTR credit given in respect of particular income can only be allowed against tax computed by reference to the same income, to the extent that it prevents unused DTR credits from being carried forward. I won't pretend to give you a full explanation of precisely the nature of the scheme, but the critical point is, in this case, the solution is this application, and I rely on it simply for that proposition. It's a taxation case. It's a case about assets moving between jurisdictions within the European Union. There is a solution by conforming interpretation. The court selects this application. Ample award is another tax case. We find that at tab 70, starting at page 2193. This is a case about VAT and warehousing. It's established that UK law was incompatible with EU law because it imposed VAT on alcohol in warehouses outside the UK. The final sentences on the front page of the header capture the question. The court considered whether section 18.3 VATA 1994 should be read down in order to conform to the UK's obligations under the principal VAT directive by restricting its application to warehousing regimes within the geographical territory of the UK. So that's the question. Do we amend by conforming interpretation to make it comply with EU law? If I can take you to paragraph 106 on page 2219. HMRC's first suggestion is in effect to replace any member state with the United Kingdom. So again, this is the conforming interpretation that's being offered. I do not consider that the Marleasing principle entitles a court to adopt an interpretation which is direct contradiction to the words that Parliament has used. Moreover, Section 18.7 specifically contemplates a warehousing regime, as including movements between warehousing in different member states. And then at the bottom, the suggested conforming interpretation would have retrospective effect, although Parliament has expressly decided it should not. And so just to clarify 2 things from this paragraph. First, this is a case in which the court is being urged, you'll anticipate my submission. It is not Parliament's intention that there be payment in instalments in this case. Parliament's intention here was to say United Kingdom, not any member state. And the court in Ample Award says, in those circumstances, we are not reading those words in. And the second submission relies on the final sentence. Because in this case, you'll see from above it, HMRC's first suggestion would, in my judgment, be contra legem. I note, however, that this amendment has in fact been made by Parliament. See Act with very long title, para 16.6d, but only with effect from 31st September 2020. And you'll apprehend what the submission is going to be. We are in a case that is squarely on all fours with that. Parliament has amended the domestic legislation, and it has decided that that will have effect only going forward. And that is something relied on by the court as relevant when deciding the threshold question of conforming interpretation or disapplication. And so I say here that this is a helpful exemplar of the kind of approach that should be taken when you're being urged down the path that the revenue is encouraging you to take. Just to pick up on a couple of authorities relied against me, and particularly important to the tribunal below. The first of those is Vodafone 2. You'll find that at Authorities tab 47. This was another tax case. It turned on the law as it applied to the taxation of profits of wholly owned foreign subsidiaries, CFCs, wholly controlled foreign companies. The structure of the legislation was that it captured a very wide range of different kinds of tax and then created a series of carve-out or exemptions such that only a very small number of circumstances went through the gateway. And that is what we take from paragraph 38. In fact, no, that's what we take from paragraph 39. I'll come back to 38 in a moment. So without any way contending it's incumbent on he who contends for conform interpretation to spell out exactly what it is, for that would be to gainsay the proposition in paragraph 37F above, and undoubtedly assist in the consideration of whether or not it's a permissible interpretation. Counsel for HMRC disclaimed any intention or requirement to produce any precise formulation. He contended that the grain or the thrust of the legislation was to cast the initial net as net wide, as in section 7473, and then to narrow it by the overlapping exceptions set out in section 7481A to E and 3. In that context, he submits all that is required is to introduce an additional exception in respect of a controlled foreign company, if it is in that accounting period actually established in another member state of the EEA and carries on genuine economic activities. There, such an exception could be an additional lettered paragraph or an additional alternative. The effect of such an amendment would be to remove from the CFC legislation the hindrance or restriction from Cadbury Schweppes. There would be no need for a case-by-case consideration. So this is a case that's relied on against me, and in that case, the court accepted that encouragement. That's why my learned friend relies on it. But we do say that that case is not like this case. That is a case where you capture a very wide body of tax and then you winnow it down through a series of exemptions. You know the structure, you know the logic of what Parliament's trying to do. The error, if I can put it that way, is that Parliament has failed to add on one further exemption. And in that case, the court says, well, we know the thrust of the legislation. We have that. That is not this case. And that's why, and I'll come back to address you on paragraphs 37 and 38 briefly, which are the overarching principles, that's why we say the outcome in Vodafone 2 doesn't help my learned friend. Of course it's right that in certain circumstances you may find a conforming interpretation. But this is a case where there is a very clear thrust and grain to the legislation, whereas what would be happening in our case would be the interpolation of a new statutory scheme that doesn't look like anything to do with exit taxes and capital gains tax under the legislation. Finally, on this authority, rather than read it to you or make submissions on it, you'll find paragraphs 37 and 38 are very helpful. 37 gives you a very bold articulation of the muscular jurisdiction, as Lord Sumption called it. 38 refers to the constraints on that. That was referred to by the Upper Tribunal. I refer you back to it for the overall approach, read alongside the other cases that I've looked at. The only other case I'd like to deal with is IDT. That's at volume 2, tab 43. I can deal with this, I hope, relatively quickly. This is a case about VAT on mobile phone services and communications. Paragraph 110 on page 889.
I'm so sorry, it's my fault. I missed the tab.
Not at all. It's tab 43. And this really goes to my lady's question earlier, and the submissions I made earlier about the different circumstances in which conforming interpretation may give rise to different kinds of outcomes. This is a case relied on quite heavily by my learned friend, paragraph 110. And really all I need to take from it is the final 2 sentences, I think. However, in the present case, it is well known that the provisions of VATA 94 have to be interpreted in conformity with the 6th directive, and that's the 6th VAT directive in EU law, and that the supply of telecommunication services constitutes a taxable supply for the purposes of the 6th directive. I therefore agree with the judge that the principle of legal certainty was not infringed in this case. So this is a case relied on by my learned friend for the proposition that you can use conforming interpretation to read in words. And we say, in answer to that, it's not like this case. Because this is a case where Parliament has intended but failed to properly give effect to the 6th VAT directive. And that is a very long way from the case before you. And just to round out that point at paragraph 113 over the page, this is not beyond the bounds of permissible interpretation because there is no indication that Parliament specifically intended to depart from the 6th directive in this respect. So this is a case relied on by my learned friend, but actually we say this is a case that's helpful to my appeal because it illustrates that there are some circumstances in which conforming interpretation is rather more straightforward when you're looking to the grain, the thrust, and the intention of Parliament. That leads me to my 4th topic, if I may, which is the judgment. I'm going to see if I can get through it before the short adjournment. It would be very helpful if I can. I apprehend that you'll have read it, so I'm not going to go through it exhaustively, but I do just want to pick up a number of points. And really, there's a very full description of the submissions, and the analysis begins in the core bundle, tab 4, page 80, at paragraph 128. And the first substantive...
If you just give me a second.
Of course, I'm sorry, madam.
Thank you.
You've probably got all 5 authorities bundles open before you because I've been rattling through them.
So I'm at core bundle.
Core tab 4.
Tab 4.
Page 80.
Thank you.
And you'll see at the top of the page there, paragraph 128, discussion. So this is where, if I can put it that way, the core or the kernel of the court's analysis and reasoning. And just picking it up first at paragraph 130, subpara 1. I mentioned this earlier, but just to close the loop on this. Our first task is to understand precisely what relevant aspects of UK domestic law infringe the EU law rights of the trustees. We draw the following conclusions from the jurisprudence of the CJEU. 1. The imposition of an exit tax on a person transferring his tax residence from one EU member state to another may constitute a restriction on that person's freedom of establishment or free movement of capital. With respect, that's wrong. It does constitute a restriction of that person's freedom of establishment or free movement of capital. And we do say that that's important because there's a point later on, which I may not take you to, where the court suggests that I'm looking through the telescope the wrong way in my submissions before the Upper Tribunal. But part of the reasoning of the Upper Tribunal, in my respectful submission, part of the reason it's looking at it the other way is because it doesn't accept the foundational proposition that there is a restriction here, in this case an unlawful restriction, and the question is, may it be made proportionate? Paragraph 2 that you have here, we agree with, an exit tax may be justified by reference to the legitimate objective of preserving the right to tax activities in the territory. 3, but it is disproportionate for the origin member state to impose an exit tax in circumstances where the taxpayer cannot defer payment of the exit tax. In my respectful submission, and this may be splitting hairs, the proper way to put the point is that the interference with free movement will only be proportionate if the taxpayer is offered a choice to defer at the point of departure. And even as I say that, I don't think I am splitting hairs, because I think it's a different way of approaching the exercise the court has to undertake. So in my submission, the proper way to put it is that the interference with free movement will only be proportionate if the taxpayer is offered a choice to defer at the point of departure. And I take that from the authorities I've shown you earlier. 4, again, subject to that qualification. 5, here it remains undecided whether paying by fewer than 5 annual instalments would be proportionate. And that's absolutely right, we just don't know. That's never been tested in the case law. Paragraph 132. We find that the breach of EU law rights of the trustees does not arise because of the imposition of an exit tax. Rather, it arises in respect of the failure of the UK to allow a deferral of the payment of that liability. Now, again, I don't wish to read this as a statute or to be unfair to the tribunal. But actually, the proper way to think about it again is the starting point is that there is an interference. And the right way to think about it, in my respectful submission, is that the interference is unlawful where the taxpayer is not allowed a choice at the point of departure, whether to defer payment of tax. And it's notable that the word choice, which is an absolute hallmark of the EU case law, doesn't feature in the kind of foundational description of what the case is about. Then when we go down to paragraph 135, the next step in the analysis is to consider what is required to remedy the defect. We can then consider when this can be done by a conforming interpretation, and if so, its terms, whether conforming interpretation is possible is a matter for domestic law, which is absolutely right. Paragraph 136, we note that the CJU in Panayi did not consider what deferral right the UK would need to give to the trustees in order for UK legislation to give effect to their EU law rights. Now, that is a slightly odd sentence, with respect, because of course the Court of Justice didn't answer that question, not just because it wasn't asked it, but because there isn't a singular answer. So the Court of Justice didn't say the way you can fix this is by doing X, because as we've seen from the authorities, there is no one single way in which that can or should or needs to be done. So it says this follows from the terms of reference to the Court of Justice, but then the next sentence, however, in its jurisprudence, the CJU has found that payment in instalments of 5 or 10 years is compatible with the taxpayer's EU law rights. True, albeit the Court of Justice has also found that deferral until realisation is compatible with EU law rights. The point that this misses out of the analysis is, or perhaps the false premise, is that there is a single preferred, ideal, simplest, or most basic way in which the UK legislation would be made lawful. Now, where things in my respectful submission really start to go awry are in paragraph 139 and 40. I invite you to read them, but to tell you why we think they're wrong, well, I'll invite you to read them and then I'll make my submissions on them. Now, two points by way of context. Firstly, the judge below, Judge Mosedale, had made it very clear she did think she had a range of options before her. I should probably defend the judge with his smorgasbord of delicacies, or judges, because that's probably counsel's responsibility, because I had referred to there being a buffet. So just to speak up, as it were, for the slightly, contextually slightly perhaps peculiar language. But what the court's saying here is they're saying we don't actually have a choice. That's their solution to the problem. So the submission has been put to them very squarely. You can choose between a variety of different options. And the court says, well, we don't actually have to choose, because what we do is we find what is the best fit and the remedy that doesn't go beyond what EU law requires. Now, just to take the first of those, because the words best fit recur at various points or analogous wording to them. Firstly, the words best fit, I can't identify from the authorities the answer that what one does is to find the best fit, and by virtue of doing so, you are relieved of any obligation to make choices. That's the purpose of this analysis within the logic. It's to say, don't worry, I'm not making choices reserved for Parliament. I can choose the best fit. The second is to say not to go beyond. Now, even if going beyond, I mean, RIAS is not authority for anything to do with going beyond, so far as I can understand, but even if it were right, and there are authorities that refer to, one doesn't go beyond what EU law requires, the difficulty for the tribunal is how it is to explain, and it doesn't explain adequately, why 5 equal instalments doesn't go beyond what EU law requires, but 3 which might be lawful or 7 that might be lawful do. Further, it doesn't explain why deferral until realisation goes beyond what EU law requires, but 5 equal instalments does. 5 equal instalments doesn't, rather, to put it the other way. So it's
not that hard to understand the 5 to 10 point.
Yes. Well, it depends. It depends on your view, my lord, because that's premised on the assumption that 10 is more generous to a taxpayer, maybe, and therefore that goes beyond. I don't think the principle of going beyond is about generosity or not generosity. The question is, how does one make it conform?
Well, but it's to do the structure of the argument is it's, as it were, prima facie a breach of the right of freedom of establishment to have these exit taxes at all. But it's also a principle of EU law that taxing authorities can tax in respect of events that happen within their own territories, including gains which accrue while a person is there.
Resident.
But the prima facie infringement of the right of establishment is only allowed if it's proportionate. It's not that hard to see why, if the Court of Justice has said that instalments over 5 years would be proportionate, it's not necessary to go beyond that in order to comply with EU law. In other words, to give longer than 5 years. I don't find that a difficult concept.
No, and I see the force of that, my lord. I think that the point is put 3 ways. The first of which is the point that you've addressed, and I do see the force of that. The second is that there is no logical basis in my submission for concluding that deferral until realisation goes beyond what is necessary, but payment in 5 equal instalments does not. I can't identify any analytical logic that would reach or sustain that conclusion, save if the reasoning of the Upper Tribunal on this would definitely be flawed, where, well, actually, if it's deferral until realisation, at least under one way one could defer until realisation, as we've discussed, then that would be that would mean the taxpayer doesn't pay in this case. Now, that definitely can't be the right way of approaching this, because the question what's going beyond what EU law requires is wholly neutral to the question of whether there is a liability to pay tax at the end of having identified what you must do. And secondly, this is a principle that's going to apply to lots and lots of taxpayers. There are many one of the unfortunate and amusing things about this case is that I get phone calls from counsel and other chambers saying, oh, can I please speak to you about this case? Because there's an absolute raft of them.
But is deferral until realisation, just exploring that for a moment, that is quite a potentially slightly ambiguous term, because it could be said, well, the tax obligation is measured by the position as at the time of emigration, moving. However, and it may be that you could have a scheme which says something, as it were, becomes due then, but not due for payment. It only becomes due for payment when the asset happens to be realised.
Yes, or what you do is you say, if it's realised within a 5-year window, and this is what most member states do, then you, or at least those that have this option have done, then you value it at that point. And you recall actually there was a reference in one of the authorities that we saw to taking into account changes in the value of the asset after departure. Sorry, that was just to flesh
but
out.
is there sorry, my question was really this, is there a clear EU authority in the sense of a European Court authority case which explains this idea of deferral until realisation? I mean, I've seen it referred to in some of the cases, but is there a case which actually says this works?
This is a mechanic that would be lawful. I'll look at that over the shorter gem. My recollection is that it forms a part of one of the options under ATAD. So the Anti-Tax Avoidance Directive that comes in later is that you can say, look, which is, again, post-dates.
I know, but that's not this. I'm really talking about whether there's a Court of Justice.
That explains the mechanics that would make it proportionate. I will have a look into that question, my lord, and try to revert on it. And if I don't manage over the short adjournment, then I will try and pass a note to Mr. Margolin on that question for tomorrow morning.
Just before we move
Yes.
on, when you were criticising the way that the Upper Tribunal formulated things, you used the phrase best fit, and I was just trying to find where the Upper Tribunal uses the phrase.
142.
142, thank you, my fault.
No, I'm very grateful.
Several
I think
steps
actually
behind
I had referred
the
to...
beat.
Yes.
Right, lovely, thank you very much.
And 141 provides the punchline, if I can put it that way, or the conclusion. We find that it is possible to apply a conforming interpretation of 59B and 59D. This can be achieved by reading words into those sections to provide that at the time before the legislation was actually amended to comply with EU law, ... a point we positively rely on for all the reasons you know and I've already made to you. These provisions should be read, should read, I think, rather than be read. A, in cases where a taxpayer's right of freedom of establishment would otherwise be infringed. B, as including an option to defer payment of the exit tax. C, in 5 equal annual instalments. D, with the first instalment payable on the normal due date for payment, and at E, at yearly intervals thereafter. And I've shown you 3ZAA, and I've made my submissions on 3ZAA, and you anticipate the submission, which is that what we have here is of course not identical, and it is in some respects more compressed, and there are other consequential factors that actually would need to form a part of this, and that was the submission I made in relation to penalties. But what we have here is something remarkably close to what Parliament did, and that's recognised by the Tribunal when it says, before the legislation was actually amended to comply with EU law. And that's important when we look at the rest of the judgment. 142, you have the point there about best fit, and 145 is the defence of this approach. We find the conforming interpretation we have adopted respects, in the word of Lord Hope in Lambert, that's the judgment quotation I've shown you, the will of Parliament, as far as this remains appropriate and preserves the integrity of statute law as far as possible. We recognise that in adopting a conforming interpretation we must not stray into interpreting legislation in a way that in effect involved statutory amendment, and we consider that we have not done so. What the court doesn't do is to unpack, in my respectful submission, ways that are persuasive why that's the case. So 146, we know from the CJU's judgment in DMC that 5 years is proportionate, whilst other deferral periods, including deferral until realisation, may also give rise to a proportionate result. The fact that there may be other potential conforming interpretations that would give effect to the appellant's EU law rights is not a reason why this tribunal cannot adopt the conforming interpretation given above. Question mark, why? In making a conforming interpretation, it is open to us to make choices provided they are not of a type that require parliamentary deliberation, choices that involve competing rights of different persons, or choices that we cannot evaluate. So they've identified succinctly, but not entirely unfairly, the test 147, having adopted a conforming interpretation that provides for payment over 5 years, UK law now conforms to EU law. There's therefore no need to induce any further provision to allow for acceleration of payment. So what they're doing here is there is an assertion that choices have not been made that are a type that require parliamentary deliberation, but no underpinning for that, save the reliance on the proposition of best fit. And I think paragraph 150 needs to be read alongside paragraph 146 to give it colour. That's just over the page 84. We recognise that when Parliament enacted a statutory deferral scheme in 3ZB and 3ZAA, so that's what you've seen, the provisions were lengthy and involved policy choices. But such drafting involving those policy choices is neither required nor permitted for a conforming interpretation. Well, we agree with the permitted, we don't agree with the required in this case. And my respectful submission, I don't understand how the court can just assert it has made no policy choices, produce a scheme which is remarkably similar to that made by Parliament, then say Parliament needed to make choices when making that scheme, and simply assert that the Upper Tribunal has not. And that, in my respectful submission, is the fallacy, the core fallacy, at the heart of this section of the judgment.
Well, you might say, for example, that Parliament, as it happens, hasn't chosen to, but Parliament could have chosen to make the exit charge payable in 10 annual instalments, had it wanted to. Whereas the Upper Tribunal's approach is a minimalist approach of saying, well, the cases show that the least that is necessary to comply with the EU law is 5 annual instalments. I mean, that's just an example.
Yes, so what the cases show is that of the cases that have been referred, the question, would a number of instalments below 5 be lawful, has never been tested. I think that's the fairest way to put it.
Well, Parliament would be pretty rash to choose something below 5, wouldn't it?
It would, in the circumstances. I agree with that, my lady, but I do think I just put that down as a qualifying marker. But the critical point is that the Upper Tribunal recognises that by choosing what it did, Parliament made choices that are reserved for Parliament as to the nature of the scheme, as to whether it's retrospective in effect, and so on and so forth. And it says that it has not done the same thing. And in my respectful submission, the answer, the sort of escape valve, is the best fit test. But there just is not an explanation for why this is better, why this is the best fit. And I do...
I think all they're saying is this is the bare minimum that's required not to interfere disproportionately with the appellant's rights of freedom of establishment. I don't think they're saying anything more complicated than that.
Well, if that is what they're saying, my lady, then my respectful submission is that that's wrong. Because there's no basis for asserting that the minimum required is 5 equal staged payments, as opposed to deferral until realisation. There are choices that have to be made here.
Well, it depends in a way on whether there are any EU cases, so to go back to my lordship's point, about that other basis.
Deferral to realisation.
Yes, because if there aren't, then...
Well, my lady, I hope I established that with you when I took you to those EU law cases earlier, that there are cases which say that deferral until realisation would be proportionate.
Well,
so there isn't.
That's what I wasn't clear about. And some of them seem to be saying you could have a system of deferral.
Yes.
I.e., time deferral, but it might be accelerated if there was.
Yes. So
in the meantime, which
yes.
is actually less than complete deferral. So that's rather in favour of the tax authority, I would have thought. So you have, say, 5 years, but if it's sold within the 5 years, then the obligation is accelerated.
Accelerated to that point.
That goes against the taxpayer and in favour of the revenue. But is there one that just says purely
deferral until realisation within a window?
Without any window?
Well, no, well, I'll check, my lord.
And if it does, then that might be considered, if it's deferral without any time period, that might be considered more generous to the taxpayer.
My lord, yes, but the question, generosity or not generosity to the taxpayer, just to come back to that.
Sorry, that language may be the wrong language, but it may be then that disproportionate or not. Is it within the range of proportionate things that the taxing authority can do, which interferes prima facie with the rights of free establishment, to do one thing rather than another? And if it's proportionate to say, okay, you have a choice of paying your tax up front or over 5 years, then isn't it, as my lady has just said, isn't this tribunal just saying, well, that's the least change that needs to be made?
Well, I don't think that is what
then complies with EU law.
So I'm mindful of the time. Maybe 2 points, and then I'll sit down. Firstly, it's not the least change that needs to be made. By way of drafting, it's considerably more complicated than saying there can be deferral and up to 5 years, but with realisation, and if the asset's realised before, then payment accelerates at that point, rather than setting out a structure for payment in 5 equal instalments and so on and so forth. But secondly, the premise, the answer to the question, do we have to choose? The premise of the answer is that there is a minimum and that there is a best fit. And neither of those things is established. There is no minimum.
Leave aside best fit a minute, but
Yes.
I think you accepted that there are cases which say that the construction should go no further than is necessary to give effect to EU law.
So there are cases that say that. They are not, and I'll again have a look, they're not normally addressing choices as between conforming interpretations. And the reason for that, just to bring this back to its heart, if it were right that the proper approach to conforming interpretation were always to say, well, what's the minimum that EU law requires and no more, then the principle that the court shouldn't choose between different policy objectives would be robbed of much of its force and meaning and application in this context. And that's why, yes, it's right that the courts do sometimes say we shouldn't go beyond what EU law requires, but the use of that as a tool to cut through the difficulty the court faces, that it's having to make policy choices, in my submission, is not right. And I don't, my own friend may correct me, but I don't see it used in the other authorities as a heuristic of that kind, or as a solution of that kind. And that is not surprising, because it comes very close to saying, well, actually, we don't really need to worry about this policy choices thing at all, which, as you've seen, is a major concern of the authorities, because we can just do what we think is the minimum to comply with EU law, and therefore we're not making choices.
But it's not a policy choice, it's simply the minimum that's required to comply with EU law. And once you've established that that's the test, there is no policy choice involved if there is a visible minimum which is necessary to comply with EU law.
And so the core of my submissions is that there is no visible minimum as regards what complies.
Well, right, but that's a different point.
Exactly.
Assume for a moment there is a minimum that's required to comply with EU law. If the court's task is to read such a restriction into the existing legislation, then what's wrong with what the Upper Tribunal did?
If it's right that there is an established on the authorities minimum or least that must be done,
Yeah.
I will take the question away and consider it further, but my starting submission, at least for now, is that you still have to recognise that there are choices to be made as between whether or not to, the classic term would be gold plating. That is the parliamentary role. And so the question is not, what is the minimum? The question is, are there choices of the kind that should be reserved to Parliament? That's what I was trying to establish from the authorities this morning.
Sorry, can I just write that down, please? So the question is not, is there a minimum?
The question is not, is there a minimum, but rather, are there a number of choices before the court by which it might select a compliant and lawful option, and the selection as between those options is a matter for Parliament?
Well, it might be thought that formulation begs the question, but anyway, that's your answer.
Begs the question in the sense, my lady, that it begs the question: is there an irreducible minimum?
Yeah.
But that's a separate question. That's an entirely separate submission. My primary submission is that there isn't an irreducible minimum here.
Yeah.
This is a separate question, which is if there is an irreducible minimum that can be identified, because all EU law requires is 5 equal stage payments,
Yeah.
and deferral until realisation goes beyond in some way, then my second submission in response to that is it is not possible to cut through the policy choices by using the knife of this far and no further, because that is still a question for Parliament. And that then comes into, there's the policy choices analysis and there's the ramifications analysis, which we saw as well, which is that choosing between may have ramifications for third parties, as of course this case does, as we know, because it affects the fiscal position of taxpayers, affects the fiscal position of the revenue, and so on and so forth. So, lady, just to be clear, that's the shape of the argument, if I can put it that way. First, there is no irreducible minimum, but even if there were, in my submission, that is not the tool that may be used to cut through where the choice is between policy solutions of various different kinds. And those are for Parliament, and they have ramifications that are for Parliament to determine.
Okay.
Lady, I'm very grateful, my ladies, my lord, I'm very grateful for your indulgence. When would you like us to return?
2:05. Thank you very much.
Right.